Thank you and good morning and welcome to the 20th annual Celebrate Invention here at the University of Michigan. I'm Drew Bennett, and this morning's session we're going to be presenting everything you need to know about open source software. Before we begin, I'd like to run through a couple of quick housekeeping items. First, this webinar is being recorded, and as a registered participant, you will be receiving a link to the video recording after the fact. So if you want to listen and maybe not take furious notes, this will be available to you if you need to review it after the fact. So please feel free to understand that. And second, if you submitted a question during the Q&A or the registration process, thanks, I appreciate that. It's certainly better when we make it informative and direct for you. If you did not, that's fine, and you have a question that you would like to pose during the session later on, please make use of the Q&A feature. The Q&A feature will be monitored by the group of folks who are helping with the program this morning, and the questions are going to be forwarded over at that time, and we'll work our very best to make sure that gets answered as we move along through the process. So I have to start with a bit of mea culpa. There's probably some I won't call it false advertising, but maybe a little bit of a overstatement in that we named this session Everything You Need to Know About Open Sourcing. And the practical reality is we could talk for a long time about this topic. One of my favorites, something that's certainly central to software work currently, but it's going to be almost everything you need to know. And I'm always happy to follow up with people after the fact and learn about your projects and understand what's going on. And of course, how we can help here from the Office of Tech Transfer. So with that said, a little bit of an outline about what we hope to get through in the next hour. Really going to talk about the basics. For some folks, we're going to kind of assume mixed knowledge, I guess, for lack of better understanding as far as how open source works. What is it not? Secondarily, get into licensing types. This is a big part of the discussion for most people are trying to understand open source, not necessarily from the technical standpoint, but from the intellectual property and legal point of view. Big fan of trying to keep it simple, so we're going to try and keep that straightforward. Third bucket, we'll talk about kind of the mechanics of open source. This is something where we tend to get a lot of good feedback about this, and it really is the question that a lot of people have with respect to, I'm doing an open source project, how do I manage this? So I'm starting to merge things together. I took a component from X that has Y license. I'm now going to distribute it, or I'm going to use it in this way. Can you help me with those mechanics? And that's something we certainly spend a lot of time on, and I'm happy to do that. Spend a little bit of time talking about patents, sponsored research, and open source and how that works and things you might want to keep in mind specific to the university environment. Finally, spend a little bit of time kind of a little bit of an overview of the state of the business of open source and some of the things that are kind of contemporary issues and approaches to it. Many people have heard about some of these things, whether it's the SSPL license, dual source, business source, Polyform project. So I'd like to review a lot of that. And then lastly, just talking about some resources that are available and things that we can provide you or things that you might find helpful. And of course, Q&A along the way. We'll try and get these questions answered as we work through the presentation today. So I always kind of like to sit with a little bit of a backdrop that says open source certainly has changed over the course of my career, starting all the way back with a quote that a lot of people are familiar with. You know, Steve Ballmer, I suspect, wishes he could take this back at some point. He's made a lot of comments after the fact that he clearly now understands kind of the value and the ecosystems around open source. But certainly the quote is directionally, I think, correct in the sense that a lot of people looked at it at the time in the early stages of open source, and even fairly recently, and really thought of it as in some ways problematic and dangerous, especially as it relates to business and innovation. And then we have people on the other side of the equation this is actually Richard Stallman that did that quote. And then Andrew did the last one, which is one of my favorites with respect to the use of open source, especially with respect to academics. I think a lot of basis of open source is procrastinating students. I am a long-standing believer in the notion that the best programmers fundamentally are lazy. So don't rebuild something that already exists, and open source is a great opportunity to put that into action. So I won't call them procrastinating, I'll call them smart programmers by picking that up. So there's a wide variety of things that you'll hear with respect to open source and kind of the history here. So what is it? Let's get to the basics of the basics. Open source is a license, and that's really the way we look at it from the tech transfer point of view. It is a licensing application. It is licensing that's applied to code, and it's a conditional license in the sense that you traditionally, when you think about a license, you're going to either do a click-through license, you're going to actually do a physical or digital signature on something. There are no signatures required in the case of open source. There's a license that goes with the code that you receive that's been released or published, and that's how it works. And the other keys to it is that the source code, central to this, the source code, the actual underlying at the ground level code, is published and made publicly available. And with that, the person taking the license or the licensee can do a large number of things with it that you can't do in a proprietary application or an application that you're simply using via an end user license. So that open source license allows you to do modifications, copy it, change it, redistribute it, and you get to do all of that without cost. Key difference. And when you think about a proprietary or a traditional license, the license says exactly the opposite of all those things. It'll say you can make a copy, but you can make a copy for a backup. You can't modify it. Not only can you not modify it, you can't make any attempt to modify it. And you certainly can't redistribute it to someone else. So those are kind of the contrast pieces with respect to the open source license. And again, key piece here being the source code, the code that you can actually get to, that is editable, that you can put into an IDE, that you can put into your own development environment and start to make modifications. Fundamentally, the key piece being the ability to avoid this concept of lock-in. And lock-in being I have a dependency on an outside source to make a modification, correction, or adjustment to the software based on my needs. So that versus compiled code in the traditional sense of things that are either provided to you as an executable that you might run locally or client server environment or a web-based deployment in a SaaS type of application. You're not really getting to the source in those cases. You're actually having access to some compiled or finished version of the actual application. So again, the open source code is a license to the source code, and it's really broad public access, and this is important, and we'll talk about this when we speak about all the individual types of licenses. It's really lots of people can get to it. So it's not just you, it's lots of other people can get to that same code base and take advantage of it. And as is the case with most things over time, there tends to be a little bit of structure around it. I always kind of find it a little bit ironic, for lack of a better way of characterizing it, that open source has structure around it. Richard Stallman, kind of in many people's eyes, considered the grandfather of open source and founder of the GNU GPL license, really, per that earlier quote, looked at it kind of on two fronts. One is the code side of it. The other side of it is really what, more of a social phenomenon or social movement, free software, the ability to actually get access to that code. But per the previous slides, the official definition, and this is something that comes out of a combination OSI and the Free Software Foundation, who are two of the big players in open source structurally, as far as putting some rigor and definition around what is open source and how does it work, has this particular definition. So I think key parts obviously being that open source software is software with the source code, and it comes with a license. And that license comes from the copyright holder, the person who originally developed it. And then it provides these specific rights, again, the ability to look at it, the ability to modify, ability to redistribute, and essentially to do that for whatever reason you feel is important and appropriate. And the last part is really central to kind of the current success of open source in the sense that it's done in a collaborative public manner. So projects are out there, they're publicly available. Many people use these projects, many people contribute to these projects, and they advance at a speed and with a level of engagement that's fundamentally different than if you have it narrowly being managed inside of a single company. And in the academic setting in particular, you can take any number of large-scale open source projects and say, well, how would your life be different if you didn't have these things? So if you imagined if you did not have access to TensorFlow, or you did not have access to Spark, or you didn't have access to Hadoop, and you can understand very, very quickly how there can be a pretty significant impact. And we'll talk about some statistics a little bit later with respect to dependencies and really the widespread use of these projects globally now at this point amongst lots and lots of folks. So the big three players really are what's called the OSI, or the Open Source Initiative, the Free Software Foundation, which was the original Stallman group, and then Creative Commons. OSI and FSF are really very much focused on software. That's where they spend their time and energy. Creative Commons gets put into this mix, and part of the reason it gets put into the mix is often there's confusion about, hey, maybe I'll use a Creative Commons license when I distribute my project. And I'll just make a quick side note here that Creative Commons is really the open source or open access equivalent for content. It's really not intended for software. Even the Creative Commons group itself, if you go on their website and you search on software, they're going to tell you this is not really the primary focus of Creative Commons. And if you need a software license, you should go back to, guess what, OSI or FSF, and utilize one of the known licenses from these groups. There are a lot of OSI approved licenses, and OSI really basically says, do these software licenses from an open source standpoint meet these basic criteria that are established in the definition? Is it publicly available? Does it provide access to source? Does it allow the user to do fundamentally what they need to do with it? And those licenses can be looked at and evaluated at the OSI site. Kind of a quick screen grab here, but they're all the licenses that you've heard of before, and a ton more licenses. There's all kinds of licenses out there. So we're familiar more likely than not, if in name only, to a lot of the primary public licenses that people use, such as the MIT license or the BSD license or Apache or GNU GPL, GPL, LGPL. These are relatively well-known brand names in the open source community. People have varying degrees of understanding with those things, but most people have at least heard those things. Well, if you go through the OSI list, there's a lot of interesting licenses in there. One of my favorites is the free beer license. Guess what? There's actually a license called that. And there's a variety of other ones. Point being, with 70 licenses at this point, and kind of to my earlier comment, there is a license out there that is probably going to address your questions or concerns. Understanding how it works is really the important part in making that selection. And the practical reality is that the majority of your licenses or your license needs are really going to be able to be managed under a handful of licenses. So keeping it simple, licenses fundamentally say three basic things or try to characterize those three basic things inside of an open source license. It's really, what can you do with this software? So what are these things that you are allowed to do? Are you allowed to redistribute? Are you allowed to use derivative works? Are you allowed to use the trademark of the project? What can you do with it? And then there's the can't bucket. So what are the things you cannot do? Well, I can't close it up and use it with a proprietary application. I can't use the trademark potentially. I can't get patent rights if there's a patent applied to it, or maybe the patent rights are in the can bucket. So it explicitly tells you things that you are not able to do with it. And then the last bucket is really the must. And the must bucket in most people's view really comes down to the fundamentals of open source software. And these things are the things that have to happen when you're using this software. And guess what? The first one is the one that is central to all open source licenses. You must attribute back to the original source. So this is the family tree concept in open source. It says, guess what? If you're going to use this project somewhere in your notice file, you're going to have to be able to provide people essentially that roadmap going back to, where did this come from? Well, it came from this project. Here's their copyright notice, etc. So generally speaking, the must aspects of these licenses really revolve around attribution. And in some cases, they have notice provisions that say, tell people what you changed. So when you redistribute, if you picked up the V1 version of this project and you made these 6 additions or changes, those are the things you have to tell people about. And they really fall into 3 basic categories. There's things that are considered highly permissive licenses, the Apache, the BSD license, the MIT license, the free beer license. Then there's a series of copyleft licenses or restrictive licenses, the Lgbl being the weakest of the copyleft licenses, and then really the stronger copyleft licenses or restrictive licenses such as the GNU GPL or the AGPL. And that's kind of the spectrum of licensing categories that are out there. And we're going to spend time going through every one of these in detail and what happens when you start using them in a project and things that you need to consider. So by way of example, kind of getting into the super permissive licenses and into the can, can't, and must buckets. If you look at some of these attributes associated with the permissive licenses, they are just exactly what you might imagine. Commercial use is #1 in each of these 3 permissive licenses. You can use it commercially, and commercially means you can take this component, and if you have a private non-open distribution, you can take it, compile it back into that distribution, and that is absolutely permissible underneath these types of licenses. Certainly you can modify it, that's kind of central to everything. Distribution, excuse me, also being a key part, so you can take it and you can give it to somebody else. And there are actually open source licenses that limit distribution, more of a actually contemporary thing that people are doing, and actually something that's pretty significant inside of the academic community, because a lot of people need to share what they have for the purposes of publication, or share what they need that they have developed for others' needs to use or to validate in a third location or an independent verification process. So those are things that are in the can bucket. In the cannot bucket, guess what? There's a common thread through all of that, and it goes right back to the central part that, I'm not a lawyer, but there are tons of lawyers involved with this, and one of the key things that lawyers tend to think a lot about is risk. And guess what? #1 on that risk list is you can't hold me liable. So if you take my project, you do something with it, it doesn't do exactly what you expected, there's a consequence. Guess what? The consequence really is something that you're going to have to take on the burden of, and the original creator of the software is not. And that makes sense when you think about it in the free sense of open source software. You're being provided it not only at no monetary cost, but you're also being provided free access in the sense of you may make modifications that don't make any sense to the original intent of the application. So liability is something that's pretty much universally disclaimed inside of an open source license. And then lastly, as I mentioned, the big thing is copyright. Where did this thing come from originally? So the notice back to the original creators, and generally that copyright notice, if you're doing something from the University of Michigan, our copyright notice is always the Circle C, the year of original creation, the Regents of the University of Michigan. And then generally speaking, in a copyright notice, you want to give a little bit more detail that says, hey, it came out of the Bennett lab and maybe the URL to the lab, or it came out of the Smith lab, or it was developed through this center, that type of stuff to provide people some sense of the history there. Most of the licenses will ask you to include the license, so include a copy of the original license so people know the terms under which that original content was acquired. And a lot of times that's just license.txt file or a reference to it. You'll see that done a lot as well. So when we get into the I can't sleep part of the evaluation of open source licenses, it's really let's read them. So when you really can't sleep or you're bored out of your mind and need to get to that place, start reading a license. Doesn't really matter whether it's an open source license or not. But this is where the rubber meets the road, and these things are super important because they describe what we just talked about. What are the limits? And the parts I've highlighted here, the first one is the MIT license, which is used by a lot of people, and most people like it, and they're going to tell you why they like it. It's like, guess what? This thing is essentially 3 paragraphs long. It's the notice, the paragraph, the one I have highlighted, and the final paragraph. But the highlighted paragraph, the above copyright notice and this permission notice shall be included in all copies or substantial portions of the software. Right back to that attribution requirement that I mentioned earlier. It's really central to this. It's like, we're going to give you a ton of flexibility, but in order to have that flexibility, the benefit back to the original creators is that notice. Where did this come from? Because someone may look at it and say, this is interesting. I'd like to collaborate with that group, or I'd like to understand more about that group, or I'd like to engage more deeply with that development pool. And that attribution and notice are really, really important in order to make that happen. And then the second permissive license that we dig into in a little more detail here is the Apache license. So this happens to be the Apache 2 license. The requirements here are really around the notice file, and a lot of people get wrapped up around this. It's like, well, what has to be in that notice file? How does it work? We'll talk a little bit about that. I think people are generally concerned about this for the right reasons. I think they probably get wrapped around the axle a little too much with respect to the mechanics of it, if you will, the specifics. I think you have to read these requirements under the guise of what's the spirit of what is intended inside of the actual provision, and then make a reasonable effort to do it. The worst thing, I think, in a lot of cases that tends to happen, especially in a highly permissive license, is if the original creator got a hold of it, didn't like your notice file, it's going to come back and say, hey, could you make the following corrections? But if you read this, it's pretty straightforward if you take it a chunk at a time. So you must give any other recipients of the work or the modification you made, derivative work, a copy of this license. And you must cause any modified files to carry the same notice stating that you changed the files. So very important to get into that and make sure that you're making an effort to document changes, tell people what's gone on. The part where people tend to get a little frustrated is the 2-sentence description of a change. Hey, I made a modification, I made X, Y, and Z faster. Well, that may be the spirit of what you did, but providing sufficient detail so that somebody understands it is certainly important. And again, going back to the lineage thing, you don't have to rewrite what you already wrote, obviously, in the description. Somebody can run a diff on those files and understand what's going on, but the intention here is really to give them a running start to understand what those modifications are. Then submission of contributions. Really key here, and the first sentence of this makes all the sense, makes pretty clear sense of what's going on here. Unless you explicitly state otherwise, any contribution submitted for inclusion in the work by you to the licensor is going to be under the terms and conditions of this license without any additional things put on top of it. What that fundamentally means is really coming back to the project side. If you submit a project contribution, or you submit something to help improve a project, it's going to be under the same terms. And that's kind of a default setting or perspective with respect to open source, is that if you're going to contribute to a Apache-based project, your contribution is going to follow the Apache terms going forward. If you contribute to a GNU or GPL project, it will continue under those same terms. And this is, there used to be a thing called a contributors agreement, or many people were asked to sign a contributors attribution agreement, basically saying, I'm giving you this and you can use it this way. That's somewhat gone out of phase and is really not something that's done a lot. So again, a place where a lot of people have questions when they call us or catch up with me is really, I'm trying to understand when I do my redistribution, what do I mechanically have to do? So what are those things that have to be actually in that file and permissive license? So in this particular case, what we're looking at is what has to happen. So when you redistribute the source or binary, what also has to go with that? Going back to the musts, I have to include the copyright notice, the license, I have to tell the changes, and I have to include notice. So if we look at the bucket of stuff here on the right, fundamentally, what you're going to distribute in Project X are all the components. So if you have a bunch of Python components and program files, you're going to distribute those things normally. But those .txt files are the ones that start to get particularly important for people to understand with respect to what is the origin of the project I'm looking at. One's that copyright.txt file, which is the file that's going to say, guess what? This work is now copyrighted by the contributors, and here's the lineage of it. Then there's the license file. So going back to the original file, you want to make sure that you include the license.txt file with that. And then the notice file. And the notice one, again, is where a lot of people tend to get a little bit wrapped around the axle on things, in the sense that the notice file is going to have a broad utility, and that the notice can be all these various things that you're trying to make sure people are aware of, and the state changes being first amongst them. I modified the following things, or I have these specific notice provisions. Sometimes that notice file goes with the distribution as a notice.txt file. Sometimes people will call it something different, README file. Sometimes people actually will put the legal notice files for their application, in a footer on a site. So it just depends on your personal mechanic of it. But the spirit of what we're trying to get to is ensuring that the copyright notice is there along with that lineage. The license file is present so people know the terms and conditions under which you're redistributing. And if you have a requirement to redistribute the original license, to do so. And then those notice components. So those tend to be the things that people are really looking for. And if they're auditing your project, those are the things they're going to spend a lot of time on. So on the other end of the spectrum, we have the GPL family of licenses, really the copyleft licenses. You'll hear people say this on occasion: once you go copyleft, you can't go copyright. And hopefully by the time we're done with this section, it'll make sense. The GPL licenses really started with Richard Stallman, and Stallman, very interesting guy. I really, somebody that I think if you really want to totally geek out on the open source side of the equation, you should spend some time reading a lot of his stuff. It is very interesting. He's incredibly interesting to hear speak. He spoke at Wayne State now 4 or 5 years ago. Very interesting talk. And he doesn't lack for an opinion, and I think that's great. And his opinion really is founded in this notion of free in the sense of access. No one should be between me and my ability to modify the software. So a lot of the heart of the GPL licenses really goes to that, and the lineage, if you will, of the AGPL and LGPL, which came after the original license, were to try to address some specific situations. You will hear people, and I say this with a giant asterisk because people are very GNU GPL centric, cringe because they don't like this comment too much, but you'll hear people say, it's a viral license or it's infectious. It isn't viral, it's not infectious. It has a set of terms and conditions that are very specific, and they do have impacts on your use, so they're things to be known about. But I think characterizing it in a light that maybe is negative is not fair really to the spirit and intentional license. And the big thing with the GPL license is fundamentally this: you can use this GPL component pretty much in any way you want. So going back to, if we look at the list here, commercial use, you can modify it and redistribute it, do lots of different things with it. The key is that you have to do it under the same terms as the original license. So in the case of all three of the GPL licenses, if you mix a permissive component, say an MIT component with a GPL component, the end product is going to end up inheriting, and this is the comment when people will call it viral, people will say you will end up inheriting the GPL license for anything you redistribute from that point forward. And that's the real key difference. But there's lots of successful projects that have been licensed under GNU GPL, and you probably use them. So Linux being key among them is deployed via this licensing technique, and it has not seemed to slow them down much. So it's really about, again, freedom in the sense of access. And again, you can read the different things here, but fundamentally what the big requirements are fundamentally is that you inherit that license in all downstream works. The other thing is that you have to disclose source. So you really can't hold the source back. The spirit of the license is that you should distribute the source with it. You shouldn't ever actually say, well, here's an executable, and if you want the source, you can ask me and I'll send it to you. They really want the bar very low, and would actually say that's just normal practice in the GPL license. Get a lot of questions about the differences between GPL and LGPL and AGPL. There's really a quick characterization of it. LGPL is often called the lesser GPL license, and it was essentially built to try and address, well, I don't really want to have that inheritance kind of activity going on with the whole project, but I'd really like to use this component. And the lesser GPL license or LGPL license was really intended to address being able to distribute a component, say, guess what, this component when I distribute it is under these terms, but the rest of it may not be. So it's keeping the component open, free access, but not necessarily incorporating everything else. And then the AGPL license, as you might imagine, somebody along the way did something that people in the GPL camp did not particularly like, and that was they set up a SaaS-based or a web deployed or network deployed application, closed it up and said, GPL license says nothing about this, so I'm not distributing, I'm actually just creating access. And the AGPL is fundamentally the thing that says, that's great, however, you can not do it as a service and not provide access. So it basically took the SaaS-based deployment and said, you can do that, but if you do that, you're still at the obligation of making the source available to people. And again, key pieces here is that license. So the first highlighted component coming out of the GNU GPL license version 3 that we're looking at here is everyone's permitted to copy and distribute verbatim copies of this license document, but changing it is not allowed. And that's the key thing about that license is basically you will do it under the same terms. So you can't come in and say, I like everything except for section fill in the blank and pull that out. And another part of it really comes back to this notion that it's a whole piece. So even if you incorporate 3 other pieces, either things you develop from the ground up, maybe a permissive license component, et cetera, merged it all up and distributed, is really the point C here. You must license the entire work as a whole under this license. So that's really what it's saying is if you want to redistribute this component, every other component you combine with it is also going to be done the same way. So that's the key part. When you hear people maybe push back a little bit on the GPL licenses, that's generally what they're looking for or looking at. And again, these are copy left licenses. So what it means is the copy is left and basically making the work freely available. The key thing to think about, we'll talk about now mixing these components together and what happens, but the key thing to think about with respect to these licensing terms is the licensing terms apply upon distribution. If you take in a component, you're using it in a project internally, you never redistribute it, you use it in your lab, there's no intention of it going any further. Most of the requirements of the license at that point are fairly benign. They really don't affect you a lot. It's upon distribution that all of these rules, if you will, or obligations actually are activated. So really important to keep that in mind. Just taking another component from somebody else does not create big challenges for you. It's when you start to think about having to distribute that somewhere else. So that's great. How does that work when I build my project and a mix of other components? And again, this is the part where people say, finally, the meat of the matter. We're going to talk about kind of combined works, derivative works, and separated components. We're going to talk about those under the context of really these kind of 4 types of licenses if you talk about proprietary software. So something you built from the ground up that's totally yours that you want to put into a proprietary license. And then the permissive licenses, the MIT Apache's BSD, and then the continuum of the copyleft restrictive licenses, the GPL licenses. So again, 3 different groups. Combined works, you bring together a bunch of different components and you distribute. Derivative works, so you bring in another component, you modify it, and then now you redistribute it within a new work. And then the last one is really trying to create separation of components as a potential way to work within these contexts. So if we talk about what I'm going to call a permissive component integration, so you're going to take something into your project that's under the Apache and BSD and MIT licenses for the sake of our example today, and you're going to combine it into a work, you're going to create proprietary software. Well, if you look at the left, the combined work, so you have these 3 components that you built, so component A, B, and C, the 3 yellow puzzle pieces, and then you go out to GitHub, you grab something that's got an Apache license on it, and you combine it. And now you want to distribute that in a proprietary piece of software. And the long and short of that is no problem. You can do that, and you can do it under a proprietary closed license. You can do it under a different type of license that you would like, not a problem. It mostly applies to the notion of, I want to close that up and now use it in my specific project. Do I have any problems with it? You don't have any problems with it. The only things you have to do are what we talked about previously. So those are the can, can't, and must things. Notice files, license files, copyright files have to be aligned with what particular permissive license requirement you've taken on. But you can absolutely release that as a proprietary piece of software. And the logic really for most people on the proprietary side is if you're in the attribution file and people know where the origins are of that project, again, if it's the Bennett project, and I have a copyright notice that tells me it's the Bennett project, and someone really wants to use that, they can go out and get it. If you ever have a application that you download and you want to see if there's open source components to it, that thing that you click through really quickly that says accept the terms, just copy that thing and look at it. And generally speaking, somewhere in that lineage, you're going to see a description of those components that have been brought back together. So I'm going to take a permissive component, and I'm not just going to merge it together or use it as a callable library or something like that, which would be more the original example, but I'm literally going to take it, I'm going to build on it. It's going to be the central piece of a project I'm doing. I'm going to make tons of modifications to it. So I now have a derivative work that is based on this original permissive piece of software. How does that work? Same thing, because of the nature of the permissive license, again, Apache BSD, MIT style licenses, you can release that as proprietary, even if the entire foundation of your project came off of this individual component. So long as you meet those can, can't, and must obligations, you can do that as a proprietary piece of software as outlined here. Moving over to the other side of the equation, where you have a weak copyleft kind of component, like an Lgbl component, a library that you want to use. You've got three pieces, again, the lower left combined work, pieces that you've built from the ground up, and you want to distribute that. If you have significant separation, and this is basically, you can identify the gray component, the Lgbl component, you can absolutely release your entire project via that proprietary license, with the exception of that one component. So essentially, if you think about the package that you would get in that case, it's going to say, here's the Drew Bennett project, the yellow parts. This is under my proprietary license. And by the way, we have a dependency on this weak copyleft component. We'll call it component X. If you want it, here's where it's at. You can see it inside of the actual distribution. It stands alone. You may have some wiring that says how to call it, but you can actually see it. So that's that concept of separation. It's a separate component that's easily identifiable, not mashed together, kind of in the concept of derivative work that we talked about previously. So a weak copyleft component integration where you create a derivative work. So this is a situation where it isn't separated. You take that copyleft component, you build on it, you extensively rework things, you add on it, and you truly create new work founded on that copyleft Lgbl component. What type of license do I have to release on it at that point? At that point, you do have to release on the same terms as the original Lgbl license, so you end up with a weak copyleft piece of software. Key difference, you didn't mix a bunch of components together, you literally took that original component and then created derivative work primarily developed off of it. So this comes to the one where, again, where we end up with a fair bit of discussion. The strong copyleft component, the GPL component or AGPL component, you do a combined work. So you bring these things together and then you redistribute. This is when you hear people use that term viral, this is what they're talking about. When it comes together, these 3, 4 components together have to inherit that original GPL license, and therefore they are released or redistributed as a strong copyleft piece of software under that original license. And that, if you go back to the earlier pieces of the presentation, those are really those highlighted words in the nitty-gritty of the license. You have to inherit the license. But then a strong copyleft component integration where you maybe have more of a true derivative work. So you take on this original GPL component and you really modify it. So rather than combining it with other pieces of software, you just use this as the heart of your project. And much like the previous scenario, those licenses are unambiguous. When you redistribute, you're going to redistribute under that license, GPL, AGPL, LGPL. And that's what we're showing on the right. So key point to keep in mind here is when you use a copyleft license, such as the GPL family, you're going to end up with a GPL product. That's what's going to happen. You're going to have to keep the code open. You're going to generally, as best form, be required to distribute the code or provide what's called equivalent access to the source code. And you're actually providing the original source. So some interesting component things to think about there relative to your project. And again, the other things, the license file, etc. Bottom line, you got to maintain basically unrestricted, equal, free access to that work. And that's the spirit of what those licenses were built on. So we run into this question a lot. I have a strong copyleft component in my build. I don't really want to use a copyleft license. What can I do? And there are ways to, the phrase would generally be work around it. There are ways to address it would probably be the way I would think about this. First thing is just simply remove it. It's like, I'm not going to use that component. You either can find an alternative component under a more permissive license. Second, you can rewrite it. I don't really like the notion of distributing it, or I have a desire to do it in a kind of a proprietary way. You can rewrite it. Again, there's no difficulty in taking a project, looking at it, fully understanding it, and understanding how it works, and then saying, yep, I understand how it works. I'm going to build something similar, equivalent, and integrate it into my project, but I'm going to do it from the ground up. You can relicense it. There are options where you can basically go to people in the original component, say, I want to relicense it. Will you allow that to happen? And there are certain circumstances where that can happen. And it's called a dual license. And Linux is actually done in a dual license where there's an open version and there's also a commercial version. Generally speaking, the commercial version is going to come with some form of support. Or you can do what the license really asks you to do, and that's release a copyleft. So moving on here for the last 15 minutes or so, really patents are something that comes out. Patent clauses are in OSS standard licenses, and sometimes they're inferred and sometimes they're explicit licenses. In the Apache license and GPL license, they have an explicit patent grant. So what does that mean? That basically means that if you have a piece of software and it's covered by a patent and you release that software under Apache or GPL, it's an explicit grant that basically says, I gave this to somebody and now I cannot sue them for patent infringement. So probably something you really need to think hard about. Other open source licenses have an inferred grant. The courts haven't really had what I would consider the ideal test case yet, but there will be one that will happen eventually where they're going to come in and say, well, does this really mean you gave this person a patent grant or not? My general inclination is if you're going to release the code open source and you have a patent, I'm going to guess that the ultimate decision on that is going to be, guess what? You gave people free access to it with probably very limited intention to protect your patent rights. Should be an interesting case. So why would you release code with an OSS license that has a patent grant on it? Our answer is, generally speaking, you're not going to do that. They're kind of mutually exclusive kind of decisions. If you have a patent, you're trying to protect something, you're trying to preserve some rights. You've probably expended a lot of energy, definitely some financial resources in getting that. You probably should not do it. A debate I'm happy to take up separately with anybody who'd like to. So there's a lot that we just blew through in about 45 minutes. And I want to spend the last 10 minutes on a couple of other pieces, but practically speaking, there's tons of licenses out there. There's lots of things that can create confusion, but about 95% of your projects really can be handled by the licenses that we just discussed and the licenses that are listed here. And the key reason to use those things in many cases is honestly, people know what they are. They're familiar, they're supported. There's a long history behind them. They're very clear. Most people understand how they work. So if you are starting to think you need to write your own open source license, my best guidance would be pause, take your pulse, think hard about that, and determine whether that needs to really happen or not. So the short message out of all that, what you think you know can hurt you. So use the resources that are available to you. One of the great things about obviously being in a university, there's lots of resources. Our office is certainly here to help. We have tons of access to experts. We have a lot of experience. If you're bringing your project together and you're just not sure what to do, pay attention. And the unfortunate reality is, with open source becoming bigger and bigger and bigger, the reality is there's more legal activity around it. And there's lots of people starting to sue and litigate and do other things that are just really not that particularly beneficial. And the reason is because scale and participation is just going through the roof. There's a really great resource from GitHub called the Octoverse. The link is there if you want to look at it, but it really talks about, you know, the absolute plethora of engagement across users, across organizations, about projects, etc. They're all out there, and organizations across the full spectrum of small to large are really, really using these licenses extensively in this process. So, you know, when you go from the Ballmer quote at the beginning to Microsoft acquiring, you know, GitHub and other large resources, that tells you kind of the state of the state. So very active, very important. And you're familiar with these projects. You're probably using these projects. This list could, you know, the proverbial NASCAR slide with all the logos could be pages upon pages upon pages. But the business of open source is big business. So there are a lot of things out there, a lot of people actively engaged in the process, a lot of successful projects, and that's all good news from my point of view. So what are those commercial types of approaches? Well, there are generally a handful of buckets that are most obvious that people can use for open source business deployments. One is professional services. You can basically say, I'm going to build custom stuff on top of this open source project for you. Canonical is a good example of that. You can go with a freemium model. There's some set of components that are free, and then there's another set of things that are incremental costs. GitHub's the classic example of this. You can have public repos, you can have a variety of different access points through Git, and you can have a bunch of private repos that you pay for and access to a variety of different tools. Red Hat, Linux, classic with respect to, you know, IBM does a lot of enterprise support on things. And then other options include SaaS-based deployments of projects such as Databricks. Lots and lots of activity in this regard, and quite frankly, the SaaS-based deployment of projects or services has become a really, really hot area, and a lot of consternation around it, to be quite honest. And then there's the multi-licensing. Lots of people do multi-licensing. MySQL does this, Red Hat does this, lots of companies do this, where there's really two versions of the product. You can have the commercial version. Commercial version is generally going to come with some form of support, may come with some incremental features. Definitely going to come with documentation, things of that nature. And then there's more of a prevailing thing, which is open core. The main part of the project is open, and then there may be other aspects of the project that are closed, proprietary, or paid. Elastic's a good example of that. I get this question a lot, and I could probably do a whole presentation on this, but it's really, hey, I have a open source machine learning model or AI method. Do you have any thoughts on this? And kind of what's really happened in a lot of cases currently is a lot of things are kind of going in a direction where maybe the model is open, or the algorithm or approach is open. You publish on it, you say this is how it is. It's A plus B plus D times some coefficient plus X. And you explain what you did, how it works, the data broadly that you worked against, and make that available. The things that are tending to be held back now, and more as a trade secret for a persistent long-term value play in the machine learning and AI space, is really a lot of stuff around the configuration, the parameterization, weights, coefficients, things of this nature. Those are being held back. If you want those, you can license those. Certainly training data, especially anything that's having some type of supervised learning involved with it, where there's human beings saying the machine is right or the machine is wrong, the annotation, incremental descriptors on top of that data. That is certainly high cost activity because it's usually an expert involved with that. And those things tend to be being things that are held back. And then lastly, really benchmarking. A lot of people are taking their application and saying, listen, I've run it against a data set, and now we're going to benchmark your activity against it. And just a quick note, there's a lot of new licensing models out there. There's kind of been a history of these moving along, but they're all an attempt to really kind of say, I don't want to have some large entity, for the most part, pick up my project and then make money off of it. There, as you might imagine, all the big cloud service providers certainly monitor all the active projects that are running on their infrastructure. And in a lot of cases, they have picked up those projects and made commercial versions of that. So there are a number of different types of licensing techniques that are being applied to that. And they're listed here. One's called the business source. There's a SSPL license, a commons clause. Well beyond this initial introductory kind of discussion, but certainly something I'm happy to talk to people about if they have specific concerns about their project. So really the summary is use a known license, know what your goals are, and understand the people that are involved and their goals as well. Kind of know what you've put into your project, know what components you're mixing in there, and then really understand what are your key drivers. You know, are they distribution? Are they getting contributions from others? Are they commercial intended? Are they really freedom-based? What are they? At the end of the day, try to keep it simple. There's a lot here. I know it can be a little bit much, so I always encourage people to kind of reach out. We have a cheat sheet that I'm happy to provide anybody who'd like it. We also do a thing called Oscar, which is just basically a short consultation if you want to talk about your project, open source consulting and review, because we got to have an acronym. But more than happy to pick that up with other people's projects. And then some resources for people. Certainly Heather Meeker is kind of a legal source for a lot of activity here. She has a great book called Open for Business. She also has a great blog called Copyleft Currents, and there's a couple other here. And I always like to give thanks to a really good colleague of mine, Chris Gear, out of the University of Minnesota. We do a lot of work together on open source and kind of borrow heavily from each other. So I always like to give him a special note. So we have a couple of quick questions. I'm going to try and go through them quickly. I know I'm way on the back end of my time, but I'm going to try and answer these on the fly. So if you have them, please feel free to submit them, but we're going to go through them real quickly. So the first question is, where can we find information pertinent to writing data management plans that include open source software to funding agencies? Hopefully, kind of what we talked about today is helpful in that regard. My best answer for the data management plans really is we're happy to consult with you. We've done this a fair bit, and really just kind of talking about where you're headed with your project and what those components are. Comparing open source and commercial off the shelf to be commercial startups' view of pros and cons of open source versus for-fee license of commercial off the shelf in development. I think it really comes down to open source isn't something, if I understand the question correctly, open source isn't something that you're going to avoid per se going forward. It's just kind of the state of affairs for software. So the question is, how can you best engage your audience and create a successful economic model in order to have that happen? Doesn't mean you have to be completely open source. There's certainly plenty of proprietary companies that do that. But if you think about the way things are going, even if you're not open source completely, you have some open access point. You have a web service, you have an API, you have some open data components. So I really think it's just a matter of sitting down and thinking about that. Promotion of open source to biotech, health IT, and IT companies. Would it appeal to a B2B audience? I think the short answer to all that is yes, absolutely. It does appeal, and it appeals because of that flexibility and the ability to drive a large community against it. And those things are super important, as we have seen by the success of these projects. I mean, I always use Tensor as the example, but TensorFlow, if it weren't available, would have huge impacts now when we think about that. And they have created a massive impact in a short period of time. And Google, you know, what is Google's direct benefit of that? I think Google's direct benefit of that is multifold across any number of categories or services they provide, and certainly creates a lot of engagement. Risks of open source. We got 2 more questions here. Is what is the biggest risk associated with open sourcing your software? I think the biggest risk from my standpoint is really simply understanding the method by which you're going to do it. I don't think that from my standpoint, releasing the code doesn't in any way, shape, or form kind of circumvent your knowledge, your know-how, your history. If you develop the project and the project is significant, you're always going to be there. So I think that's it. I think the risk, of course, is somebody else can pick it up. They can do something fantastic with it. But I don't know if I look at that as a risk as much as it is probably the best compliment that you could get, is that it was good enough to use and people have taken that and run with it. So the last 2 quick questions, and I know we're over a little bit, is are open source licenses respected on a global basis or just in the USA? It's a great question. Generally speaking, they are international and people do respect them internationally. So companies are using them all over the world, and generally speaking, that would be the case. And my last one, and this is a good one, kind of very specific, taking an example of GPL versus AGPL. Let's say I wrote some code and licensed it under GPL, and at the time, SaaS was not a thing yet. Fast forward a few years and the commercial developers started using my code in their SaaS products and ignore my GPL license. Can I update it to become AGPL? In other words, can existing license types be amended and modified when the reality changes? As long as the downstream combination is allowable, so kind of going back to if you take a copy, a permissive license and merge it with the copyleft license, you're going to get a copyleft license. You can certainly move from GPL to AGPL. The key thing that I think is important in your question is if it was June 2015 and your project was released under GPL, and that's when the company took it, and then you changed your license, they accepted it under the terms that they took the original code. So you can't kind of reverse reinforce some new requirements on them. And hopefully that makes sense. If it doesn't, please feel free to reach out to me. 3 minutes over, my apologies. Hopefully we got through everything. I really appreciate everybody taking some time to be with us this morning. Hopefully this was helpful to you. Please feel free to reach out. We're here to help. And I hope you have a great day. Thanks for spending some time with us at Celebrate Invention.